Good evening. Welcome to this UKLFI Charitable Trust webinar on using litigation to stop BDS. I'm extremely pleased to be joined by Marc Zell, a distinguished lawyer who has an enviable track record of prominent victories against BDS. These include the Ariel University solar Decathlon case in Spain, where in 2016, the Spanish Supreme Court issued a landmark ruling against the country's housing ministry for illegally excluding Israel's Ariel University from a scientific competition in 2009. That was a significant setback for the Spanish BDS movement, with reports of a six-figure sum awarded to the university. Marc's cases also include victories over the attempted boycotts by Airbnb and Ben Jerry's. Airbnb sought to remove Jewish West Bank listings from its website in 2018, but it changed its policy after two federal court settlements and after Ben Jerry's sought not to renew its contract with its Israeli licensee when he refused to stop selling ice cream in parts of the country. Marc was engaged to challenge the legality of that decision. At the end of June 2022, Ben Jerry's parent company, Unilever, agreed to sell the entire Ben Jerry's business in Israel to the Israeli licensee, Avi Zinger. Originally from Washington, D.C., Marc founded Zell, Aaron & Co. He is an experienced transnational litigator, successfully representing business clients in complex litigations and arbitrations around the world, and also acting, as well as, I should say, acting against BDS. He's acted in significant cases seeking restitution or compensation for property taken during the Holocaust. Marc is a graduate of Princeton University and the University of Maryland School of Law, and is a member of bars at the State of Maryland, District of Columbia, Virginia, the United States Supreme Court, and Israel. Marc, I'm thrilled that you are with us to share your experiences of stopping BDS against Israel, and we look forward to your presentation drawing lessons from these encouraging results. You're very welcome.
Thank you, Natasha, and good evening or good afternoon, as the case may be, to all those who are attending tonight's webinar. I want to say a special word of thanks to Jonathan and Caroline Turner at the UKLFI, and of course to Natasha for making this webinar possible. Now, let me do what I'm supposed to do now and put the PowerPoint on the screen. Natasha, can you see that all right?
I can indeed.
All right, great. All right, well, I thought I really would like to spend as much time answering questions as possible, and therefore I don't want to spend too much time on my own PowerPoint presentation. I've made it rather brief, and so with your permission, I'll just go quickly through the presentation and make a couple of points that set the stage for our discussion this evening. Now, let's see. That's great. Why isn't that working? All right. Murphy's Law is in full swing here. Just a minute.
It may be.
All right. Okay. Well, I think we need to spend a great deal of time discussing what BDS is, boycott, divestment, and sanctions. It's a Palestinian-led movement, unfortunately also contributed to by a disproportionate number of Jewish activists around the world who support this idea, and this movement, which is aimed at not just limiting Israeli economic activity or any particular part of the land of Israel, such as Judea and Samaria or East Jerusalem or the Golan Heights, but really its goal is weakening and ultimately eliminating all of the state of Israel as a Jewish state. My role in this is a little bit different than some of the others that you may be familiar with, which are led by really first-rate organizations like the Brandeis Center in the United States and UKLFI in UK and other organizations of that ilk around the world. I'm a private attorney, and what I've done in this area has really been on behalf of private clients or just as an interested member of the public. But because these issues are of great and overweening public importance to Israel and really to the rule of law internationally, this is something I feel as a professional I need to devote my time to, even though oftentimes it would not necessarily result in remuneration, but it's important to do as a professional. Tonight, we're going to be talking about a few of the cases that Natasha's already mentioned. The Ariel solo decathlon case from 2010, which was decided, Natasha, just a brief correction, in 2012-13 by the Spanish High Court. But the 2016 date that you mentioned is important because that is when the Spanish Supreme Court ruled generally in another suit that abiding by the BDS or following the BDS movement was a violation of Spanish discrimination legislation. So that's our case led the way to the more recent case in the Spanish High Court. Airbnb, we'll talk about in a minute. Ben & Jerry's, many of you are familiar with, and in a case like Ben & Jerry's in particular, I need to state at the outset that while I was played a central role in that case, I was hardly alone, and I need to acknowledge certainly the tremendous help that we had from the Brandeis Center with Relisa Lewin, who I believe gave a webinar to the organization just a couple of weeks ago, and her dad, Nat Lewin, a prominent litigator in the United States. We all worked together in a very closely coordinated effort that brought about those amazing results that Natasha referred to. There have been other cases as well that less successful. General Mills is a case that was brought, a case that happened in Israel and didn't turn out as well. That was not one that I was involved with. Not to say that my involvement is a necessary condition to success, hardly. The EU labeling discriminating cases in the G4S security case that we've seen, but there have been others in other countries, like the case that was brought in France that Jonathan kindly provided me with a copy of the Astrom. I think it's Jonathan, correct me, I don't want to mispronounce it, and I'm looking for it, and of course I can't put my hand. Oh, here it is. Yeah, it's the France-Palestine Solidarity Association against Alstom Transport SA, which was decided by the French court, the Court of Appeal of Versailles, a couple of years ago. Amazing victory there too. Anyway, so let's go on into kind of a general overview of the kind of responses that have been effective in combating BS. Judicial remedies, or you'll see at the bottom of my list, are just one of the various tools that can be used. Perhaps the most effective of all are the public education and public relations efforts being made by organizations like UKLFI. I think during the course of this webinar, I'm going to ask Natasha to give you an overview of the wonderful things that they've have been able to accomplish in the UK. And including in Wales and Scotland, Northern Ireland, and so on. I'll let her give you an overview of that. In the United States, the legislative initiative has taken place primarily at the state level. As you know, the United States is a federal system. And so legislation is enacted both at the federal level out of Washington, D.C., and also at the state level in the 50 state jurisdictions, and also in territories like the District of Columbia and other outlying territories. These initiatives have led to some close to or in excess of 30 states which have enacted anti-BDS legislation. The interesting thing in this area happens to be the judicial response to the anti-BDS legislation that's been enacted across the United States And the leading case in this area is the one I mentioned in the slide called Arkansas Times LP versus Waldrop. And that's a case that came out of the United States Court of Appeals for the Eighth Circuit. But another case called A&R Engineering versus Scott at the moment is now pending in the Fifth Circuit. It comes out of Texas, Houston, Texas. And this case is an appeal that's pending before the circuit where the BDS advocates won an injunction at the trial court level. And now the question is whether the Fifth Circuit will follow the Eighth Circuit in reversing the trial court's decision and upholding the BDS legislation against a First Amendment challenge, which is an issue in both cases. I think, depending on how these cases, the new case goes, there's a high probability that the case will end up in the United States Supreme Court, although the Supreme Court denied review in the Arkansas Times case only because that was really the first of what may be many such decisions. And then there is the area of executive action, which has taken place in the United States again at the state and federal level, primarily at the state level. And here we see efforts by the active anti-BDS groups around the country to bar or limit investments by state pension funds and other organizations in companies who have embraced the BDS initiative, so in the BDS program. And that's been very effective throughout the United States, many states, including the Ben Jerry's case, which I'll mention when I get there in a moment. And again, see results in the UK. And Natasha, I'll maybe ask you to talk about that when we get to that point. Finally, we get judicial remedies, and there are a bunch of them here. The kind of cases that I've been involved with thus far have been direct civil actions where we've challenged the BDS compatriots or BDS co-conspirators, we can call them, directly in lawsuits, both around the United States and in Spain. The second type of proceeding is a class action. We all know what that is. I won't go into a description, but this is where we had recently in the Ben Jerry's case, two class actions which were consolidated and brought against Unilever in Israel. And in the wake of the positive decision in our case, they were settled and dismissed. A third type of action, which is still pending, and again, arising out of the Ben Jerry's litigation, is a shareholder derivative suit, where shareholders in the company, the complying companies, with pro-BDS companies like Unilever, for example, have brought what they call derivative suits under local and federal law to challenge the actions of the companies, which they allege resulted in a diminution in value of the individual shareholdings in the company. That case in the United States, in the Southern District of New York, has largely remained dormant since December of 2022, in which, following the favorable result in our case, in the Ben Jerry's case. And finally, there have been some criminal actions as well, which is beyond the discussion here tonight. Very briefly, I think Natasha has done a great job in summarizing our claim against Spain. The only thing I would want to say here is that, first of all, I had a big fight with the university that was Ariel University, which was the principal plaintiff in the case, just to get them to agree to file this action. They were very reluctant at first, thinking that this was going to result in a wave of retribution brought by donors and other governments. Particularly the academics were worried that this would somehow redound against them. And fortunately, I was able to persuade the administration to go ahead with this case, and the result was a $100,000 US dollar award in favor of the university, something completely unimaginable at the time we began the lawsuit. In this case, I want to give a special recognition to the Crematis firm out of Madrid, which worked with us on very close basis to make this happen. The next case came in around 2018, if I'm not mistaken, 2019, was an attempt by Airbnb responding again to BDS initiatives and something called the Human Rights Watch, which was arguing that they should not, Airbnb should not allow for any accommodations to be made available to the public in Judea and Samaria. And we felt that this was outrageous, and this was a really initiative that I founded. I found the plaintiffs around the country who were accommodations owners, and we decided to do something that turned out to be very critical. There were several other cases brought elsewhere in the country, but the one that really, the straw that broke the camel's back was this one, where we brought the lawsuit in Airbnb's backyard in San Francisco, the Northern District of California. And we created, really for the first time, a variety of causes of action, both under federal law, which is the Fair Housing Act, and 3 state law statutory cases, the California Fair Employment and Housing Act, the Unruh Civil Rights Act, and the California Unfair Competition Law. What happened, though, because of we'll talk about this, the very good fortune and the timing of the lawsuit, the Airbnb capitulated on motion at the time of the motion to dismiss, and we ended up achieving a major settlement in that case, a really extraordinary result. And finally, among the 3 case studies that I brought here that I've been involved with is the famous Zinger versus Unilever and Ben Jerry's action. All of you, which you're familiar with, Eliza may well have talked about it during her webinar. Like, I don't want to rehash what has been said already. But what I want to say here is a couple of things. First of all, one of the things that we did in this case was we adopted a very creative theory of recovery, this wrongful termination theory. I mean, everybody that heard about this case when it first came up in 2021, I think, when they announced their intention, Unilever's intention to terminate the 35-year-old manufacturing license at Avi Zinger's company, was that this will never work. There's no way. I mean, they have the argument was Unilever has a complete and unfettered right to terminate the contract. In fact, it was going to end by its own terms, expire under its own terms in December. And all Unilever was going to do is say, we're not going to renew it. So everybody said to us, you have no chance of winning this case. Well, Nat Lewin and I worked on this new theory, which we borrowed from the area of employment law and applied it in this area of commercial law, and said, listen, okay, you've announced Unilever that you're not renewing our contract because we refuse to abide by your instruction to violate Israeli boycott legislation and anti-discrimination legislation by refusing to go along with your request, your demand that we not sell our ice cream to Jews and Arabs in Judea and Samaria. And this is simply against public policy. It's outrageous, and they vigorously defended this, but eventually, within the span of about 3 months, completely changed their tune in the beginning of June of 2022, and decided and came back to us and said, listen, we are willing to resolve this in a way that you may find very interesting. And what that was to not just to renew our manufacturing licenses, which is what we were after, but to sell Avi Zinger and his companies the entire right to do business and to manufacture Ben and Jerry's ice cream throughout Israel, including specifically Judea and Samaria, and to give us the sole right to do so among all companies in the world, including Unilever companies. And I was privileged to lead the negotiations at Cravath, Swaine and Moore in New York on behalf with Unilever, and worked out an amazing a set of agreements which implemented this decision to sell the business to Avi Zinger, the first of its kind in Unilever, to my knowledge, and in the world. there was an interesting epilogue to this case, and that which nobody could quite fathom. After we had sued and successfully settled the case against Unilever, Ben and Jerry's Vermont, which is a wholly owned subsidiary of Unilever, you can believe this, filed a lawsuit against its own parent company, alleging violations of a 2000-2001 merger agreement, and that the Unilever, saying that the Unilever settlement with my client, with Avi Zinger and his companies, was prohibited by that merger agreement. Well, that was filed in the Southern District of New York, as opposed to the New Jersey federal court, where we filed our first case against Ben and Jerry's, and fortunately, the court refused to issue an injunction, and ultimately, Ben and Jerry's relented, and the case went away. So that's the Ben and Jerry's litigation in a nutshell. I just have the following few comments to make. What can we learn from all this? Judicial remedies can be effective if they are properly framed in terms of causes of action, in terms of the proper defendants, the places of venue, and so on, jurisdiction. It's not these aren't easy cases to establish, and a lot of mistakes are made when people don't take the time to really think these issues through. And even more importantly, or as important, is the timing of these issues. I mentioned the Ben and Jerry's case because they were facing an enormous amount of pressure from the public and from pension funds who were investing in Unilever and other stockholders. We really were not going to put up with Unilever's hardline approach to Avi Zinger. In the Airbnb case, it was even more interesting, the timing factor, because they were on the brink of an IPO, we later learned. And that was a factor that really incentivized them to come to the table very quickly and very generously. Legislative initiatives are extremely important tools, as we've seen in the United States. Maybe this is the time to kick it over to Natasha for a brief discussion of what you all been able to do in the UK, and the public education point is also related to this. So Natasha, is it okay for me to let you run with it for a few moments?
I'd certainly be very happy to. And I had a couple of questions that I was burning to ask you before, and perhaps we'll move on in the course of our conversation to legislative initiatives, because it would be wonderful to compare what's going on here in the UK with Israel and the US, which I appreciate you have a great deal of experience in. I should say first, Mark, that I'm extremely grateful in particular for your insights, and if we can end the screen share, that would be wonderful. I'm particularly grateful for your insights in the Ben and Jerry's case, because although we did have Eliza Lewin on last month, she was talking about Zionism as anti-Zionism as national origin discrimination. So our audience has now had the opportunity to hear firsthand from the initiatives that you and Eliza were conducting together in concert. Could I begin with a general question, and I'm sure we'll be able to take more questions from the Q&A facility as our audience pose them within that facility on Zoom. Mark, many people consider that the BDS movement makes a lot of noise, but does not in reality pose much of a threat to Israel, which continues, of course, to enjoy its A1 rating with Moody's, and as the startup nation has a tech sector that leads the world. As a general first question, could we start with what your views are on the reality of the threat that BDS presents?
That's an excellent question. It's one that we discussed at length in the Ben and Jerry's case, for example, with the representative of the Israeli Foreign Ministry, who take these cases with extreme interest and concern. You are right. And the people that say that BDS has thus far not had any kind of significant impact on the Israeli economy, that is true. But that may not always be true. And in addition to that, there are impacts that the BDS movement has on the political discussions that occur at the international level, on a diplomatic level. that outweigh perhaps their actual effect on Israeli business, the Israeli economy. And that is why the foreign ministry in Israel has taken such a leading role and working to try to combat these types of initiatives around the world. We can't overstate the potential impact of BDS on the way people think. In the United States, for example, among the Generation Z, the young generation, okay, their parents and grandparents' traditional support for the state of Israel, you don't see it. And one of the concerns that we have is that the impact of this BDS narrative on these future leaders and future voters in the United States, and it's true elsewhere around the world, I would imagine. You can comment on the UK. In Ben and Jerry's area, for example, it was the activism of this relatively small but very vocal group of young people in Vermont and around the United States. It brought the Ben and Jerry's board of directors to reverse its position on the manufacturing license for Avi Zinger and his companies in Israel. They had, when they had started as far back as 2014, putting pressure on Ben and Jerry's franchisees around the United States and on the company directly, and had very little impact. But over a period of about 6 or 7 years, that all changed, and the company did a complete 180-degree reversal and went along with them on every issue. And it was only our private response through the courts that forestalled what could have been a disastrous decision. Ben and Jerry's is not just any other brand. It's a brand in which the owners, Jerry Greenfeld and Ben Cohen, from the very outset took a very activist role in terms of public responsibility of companies. And in today's world, I'll finish with this, Natasha, where companies are becoming, I think, excessively responsive or sensitive to EGS, types of woke issues, and to the extent where they're even ignoring the financial interests of their own shareholders in favor of these alternative public policy positions. This is very, very dangerous. And what we needed to do in the Ben and Jerry's case and these other cases to show these companies, no, you cannot, follow like lemmings into the desert of wokeism. You need to think about your responsibility to your shareholders and to justice and morality of a different sort, of the sort that undermines the existence of the state of Israel, the whole Zionist movement, and the right of the Jewish people to self-determination.
If I might, in fact, pick up on that last point and ask how you've seen perhaps ESG impacting on the BDS's methods of targeting Israel. I mean, there seems to be increased pressure with of course, these perverse campaigns citing ESG, environmental social governance principles, and CSR, corporate social responsibility, campaigns which single out the Jewish state and seek to isolate Israel economically in the name of socially responsible investment. But have you seen this manifest itself, perhaps outside of the Ben and Jerry's case itself, in other matters that you've been involved in?
Sure. Well, I haven't been involved with it, but I'm familiar with the General Mills decision to withdraw its manufacturing from Israel. I was counsel in another area to the SodaStream company, which had manufacturing facilities in Judea near Ma'ale Adumim, and they were forced by the ESG movement to relocate their manufacturing plant inside the pre-67 boundaries of the state of Israel, to the detriment of hundreds of Palestinian Arab workers who were basically discharged and rendered unemployed because of this decision. I mean, it is a real phenomenon. You can see it also in areas of other public policy areas. It's not just about economics. Just as the BDS movement is just not about economics. You can see it in the position of Well, I don't want to mention particular parties because that would not necessarily be in the spirit of bipartisanship. But I have to say that the influence of these of donors and this particular part of the electorate is perhaps disproportionate, but extremely effective, and in terms of changing political positions of major political parties and governments.
And
So
so often,
it is
of
a
course,
big issue.
yes, it perhaps comes down to individuals, key individuals. Of course, the board chair of Ben& Jerry's, Anurada Mittal, I believe she was, had a key role to play in the direction that, or the change of direction perhaps, that Ben& Jerry's itself undertook.
She did, but she wasn't alone. And she couldn't have done what, I mean, she led the board of directors, majority of the board of directors of the Vermont company to radically change their position in response to these arguments.
And what do you think was the role then of US states invoking anti-BDS legislation? Of course, we had from DeSantis the instruction that pensions funds should withdraw investments from Unilever. A number of other US states were involved. To what
I think it was extremely important. And it wasn't all through legislation. The legislation, I don't want to understate the importance of the legislation because that sets policy in these states all across the United States. But it was also, for example, in New York, where they don't have to my recollection, they don't have an anti-BDS legislation. But nevertheless, the governor of New York decided to give an instruction to the New York Pension Fund, and after the Ben & Jerry's issue broke, for them to divest their investments from Unilever. Okay, that was not a result of legislation; it was a result of a executive action. In New Jersey, by contrast, just across the Bay or the Hudson River, the state did have very carefully worded and very powerfully worded anti-BDS legislation, which directed, the primary remedy was to cause state agencies like the state pension funds to divest when their agencies violated the requirements and limitations of the anti-BDS law. And in Florida, I think you had both legislation and an executive action requiring divestment of the Florida pension funds. In Illinois as well. A lot of states where you did not have strong BDS legislation, but nevertheless you had strong executive action that was keenly felt by the corporations who were deciding to pursue this ESG agenda.
And thus far in the US, of course, the courts do seem to have upheld the anti-BDS legislation against constitutional challenges under
Well, okay, so let me be careful about that. And the only appellate decision of which I'm aware, I'd mentioned that that's the Arkansas Times LP versus Waldrop. That's what happened in the Eighth Circuit. And it happened on what they call an en-banc review, okay? In other words, the plaintiffs, the BDS plaintiffs, won in the district court. They won in the first appeal, which is before a 3-judge panel, over 1 judge dissented. And then only at the en-banc level, where the entire appellate courts, a very unusual proceeding in the United States, convened to review the decision of the 3-judge panel and reversed it in favor of the anti-BDS legislation. I also mentioned that in the Fifth Circuit out of Texas now, that case, we're waiting for a decision. It's already been briefed, fully argued back in November of 22, and we should get an opinion from the Fifth Circuit any day. Who knows where that's going to go? That's just in front of a 3-judge panel. And the other thing I have to say, Natasha, is we should be very careful about this, is that many cases where where BDS issues have come up on an individual level, like at the universities and in employment contexts and in certain other public contract arenas, the anti-BDS forces lost, and the cases were settled in favor of the BDS movement. So this is an ongoing struggle, and we cannot let up our guard one instance. We have to keep going.
Well, I'm afraid it's often a similar story in the UK. It is a multifaceted situation. That there are a number of legal tools here in the United Kingdom, legislation from the 1980s, which provides for the exclusion of non-commercial considerations in procurement by local government. And that's the 1998 Act. And we also have the EU Procurement Directive, which has been implemented in the UK. And that provides for the exclusion of non-commercial considerations in public procurement generally. But of course, I should say we were UKLFI and under the leadership of Jonathan Turner in particular, we were successful in using that. It does seem to encourage the Welsh government to drop its BDS proposals. But that is about to be replaced by the procurement bill currently passing through the UK Parliament. And another key factor for us to weigh into the equation here is the Equality Act 2010, and in particular, Section 149, the Public Sector Equality Duty. And that provides that a public authority must, when exercising its functions, have due regard for the need to, in a nutshell, eliminate discrimination, advance equality of opportunity, and foster good relations. The duty to have regard to those specified considerations was something that UKLFI successfully invoked against Lancaster City Council when it sought to pass a BDS resolution. Also in the UK, we have the fiduciary duties of trustees and managers of pensions funds at common law. That is another factor we invoke successfully, for example, to counter divestment by Merseyside Pensions Fund. And generally, there is also guidance from government to local government pension schemes not to engage in boycotts of foreign countries. And in fact, in part, due to a UK Supreme Court decision against the Secretary of State for implementing that guidance, so exactly along the scenario that you had just raised. As a result of that adverse Supreme Court decision, two things have happened. The power to give guidance was extended by the Public Service Pensions and Judicial Officers Act 2022. And in 2019, we had in the Conservative Manifesto a commitment for legislation to prohibit BDS by public authorities. And that is being advanced. It has not been introduced into Parliament yet, but it is promised soon. So it is an often changing picture in the UK. But I'm also sure that our audience will be interested in what legislation exists in Israel itself to prevent boycotts.
Yeah, I'll quickly address that. It's kind of ironic in a way that Israel, which is obviously the target of all this BDS activity around the world, it took its many years to finally adopt legislation to fight it. And it came in the form of two principal laws. One is the anti-boycott law, we'll call it, and the second one is an anti-discrimination law. Indeed, if I'm not mistaken, when one of these laws, I think it was the anti-boycott law, came to the Israeli Supreme Court, they struck down some portions of it. So when we were relying upon it in the Ben and Jerry's case and the other two cases that I mentioned to you, the class actions that were filed in Israel were based upon these statutes. We had to do so without the benefit of these other provisions that the Supreme Court limited. But both of them, basically the thrust of these laws is that it's not sufficient, it's not permitted for any kind of private actor or the state for that matter to discriminate against persons on the basis of their place of residence. Okay, and what is this aimed at? Of course, the argument that Jews living in Judea and Samaria are somehow second-class citizens and can be discriminated against willy-nilly because of the political debate concerning their place of residence. That was an issue. That was the problem in Airbnb, the Airbnb case, and of course we didn't bring it under Israeli law. We brought it under American law and California law. But in Israel, these issues are yet to be decided. Because these cases that were brought in the wake of the Ben Jerry's dispute were resolved without any kind of judicial determination. Finally, these issues remain open in Israel, and it remains to be seen whether the Israeli courts will have the gumption to allow these laws to be enforced as the Knesset intended them to be. That, of course, is an issue that's tied up with the current controversy in Israel about the role of the courts in Israeli democracy in general, which you're all familiar with, and which I don't propose getting into today. But
that's taking us, dangerously close to a whole nother subject. Although we have covered that in a number of webinars, and I anticipate as it develops, we'll be coming back to the subject. That's absolutely right. Mark, we've covered a number of the areas that have been raised by members of the audience through the Q&A facility. One question in particular, though, I wanted to put to you directly, which is, to what extent can it be said that directors of companies which promote BDS are acting ultra vires and against the best commercial interests of the company, making those directors potentially liable for the losses sustained for their company? I mean, I mentioned fiduciary duties briefly. I know it's factored into some of the work that you've done, but perhaps could you talk about the issue generally? And
I think Natasha, the UKLFI has taken a very important pioneering role in raising these issues. We also dealt with it in the Ben and Jerry's litigation in our complaints. It was not an issue that was ultimately decided by the courts, but I think it is a very important one, and one that's has resonated with state governments. For example, in the state of Florida, where Governor Ron DeSantis has been very active in sponsoring legislation. But I think in this past legislative term, anti-ESG legislation was passed, and it was based on the very principle that you just articulated, and that is the job of a company and the company management, in our world, is to maximize profits for its shareholders. That is the primary role of the corporate form in our society. And when now, not to say that corporations don't have the right under the U.S. Constitution in any case to right of free speech, they do, and that's an issue that's going to be hashed out in the fight between the Disney organization and Governor DeSantis and the Florida legislature in the coming months. But it becomes very dangerous when the companies like Ben and Jerry's. I mean, this was the Ben and Jerry's Vermont. When they signed up and they sold their business to Unilever in 2000 and 2001, the parties to the merger agreements were very careful in defining the respective areas of autonomy that the Unilever board as the owner of the business on the one hand could have, and those of the Ben and Jerry's local board. And that was the whole dispute. And it got to the point where the tail was wagging the dog, where the subsidiary, wholly owned subsidiary, was basically telling its corporate management, upstream corporate management, that they could not run the company for the benefit of their shareholders, for the financial benefit of the shareholders, because of these overweening CSR, ESG policies at the subsidiary level. And fortunately, it was a struggle. I can't get into too many details within our common front with Unilever to get them to understand how important it was for them to put their foot down and to say no. Okay, so your question is very, very germane and has yet to be resolved, particularly with respect to common law fiduciary duties or fiduciary duties arising under a state and federal, state corporate law, like in Delaware, which will probably be a venue for some of these issues to be played out in the not too distant future.
And of course, it's critical to point out that this is in fact an abuse of ESG as opposed to its correct deployment. Israel leads the way in many environmental considerations and social governance policies. So it really is a misrepresentation of supposed human rights considerations that seem to underpin a great deal of the ESG considerations, and it's being used as a political tool. But I am encouraged that there is some reform being considered of ESG reporting considerations and requirements on companies in the UK. So it's something that we're following closely.
US, there's a lot of pushback now around the country about this, and we'll see how that plays out. It will be one of the issues that the parties will be discussing in the general election in 2024.
There's another question here, which is a little bit off topic, but I thought I would put it to you nonetheless. And our questioner asks, is it possible to bring litigation against journalists and media organizations? And it references some choice organizations that are considered by the questioner to be anti-Semitic, or perhaps to promote some anti-Semitic tropes. Of course, that is part and parcel of what the BDS movement is pushing forward, and but for so much of that coverage, it's entirely possible that the initiatives that you have thwarted may not have gotten so far. So do you have any thoughts on what legal remedies there may be in that context?
Well, that's a difficult and sensitive question, obviously, because when you're talking about, now again, I can't speak to the UK, but in the United States, where we have a constitutional amendment, the First Amendment, which expressly protects the right of the press and against governmental intervention. We have to be very careful here. It doesn't mean that there is a total lack of remedy. For example, we know from the First Amendment that defamation, is not protected. Libel and slander are not protected by the First Amendment. So if a media organization engages in defamatory conduct, makes defamatory statements, that's one way that they may well be subject to judicial redress. And in other areas, in the area of hate speech, in the past it was called fighting speech, in the Supreme Court decisions from the 1940s. But those statutes, that regulate hate speech, may also be applicable in the BDS context where the offending organization is engaging in anti-Semitic diatribe. They don't have a free reign to engage in this kind of speech. If they, and now admittedly the line is difficult to discern, especially when the political figures, and here I'll get into a little bit of politics in the United States. Recently, the White House, the Biden administration was asked to endorse and to adopt the IHRA definition of anti-Semitism, and which I presume our viewers are familiar with, and they declined to do so. And this raised a lot of eyebrows among Jewish organizations in the United States and others who were expecting that the United States government, after having been a party to the agreements in 2009, I think, which gave rise to the IHR definition, backed off again in response to extreme progressive views within the administration about this definition. And as we know, that definition connects anti-Semitism to anti-Zionism in inappropriate cases. So
in a number of the examples that it gives, absolutely. And we've certainly been following very closely the National Strategy to Counter Anti-Semitism, which was released only last week, I think. But as you say, extraordinary in that strategy seemed to distance itself from the IHRA definition entirely. And
it shows you what we're up against. I mean, it's not this is not a slam dunk kind of issue, hardly. There's going to be a lot of public debate about this.
Mark, one of the questioners has asked whether you might make your PowerPoint available for download, and if you're
sure, you have it, Natasha.
Yes, then we'll be sure to send that out with the recording link for this webinar. We're very grateful for that.
And I apologize for it being so short, but again, I really wanted to give more time to the audience's questions and your questions too, Natasha, of course, which have been excellent.
Well, and it gave a brilliant overview for the start of this session. One further questioner asks, what is the core or the center of the BDS movement? Now, I imagine and anticipate that in the work that you have done countering these instances of BDS, you may have also conducted some research into the phenomenon of the movement and where it started and what's behind it. Are you content to share some of your learnings with our audience?
I can share some of my thoughts about this. I don't want to portray them as being hard facts, but we know from our own research and studying the actions of the principal activists. I won't mention their names, but there's a small cadre of BDS activists that constantly show up around the globe, and we also know where they draw their support, financial and moral. And a lot of people would like to blame Arab countries alone for this. I'm afraid that simply would be an exaggeration. Okay, there is obviously support for the BDS traditionally. It's been for decades, from sources in their places in the Arab world, Arab governments, including some that have now moved closer to diplomatic ties with the state of Israel. But a lot of the support for this movement is coming from Jews and Jewish organizations. And again, I don't want to necessarily, I don't want to offend anybody in the audience, but there is a problem here, that we find that many Jewish organizations, even in Israel, it's hard to believe, but even in Israel, in fact, I just debated one of these fellows yesterday in front of a college university class in Israel, in Rishon LeZion, and this fellow unabashedly stood up, a Jewish activist who was spouting out all of this pro BDS language and expressions of support for against his own country. Okay, and there have been others, academics in particular, some of whom are, I think, residing in the UK, who have taken a very anti-Israel, anti-Jewish, I would say anti-Semitic, okay, approach to this, and they are very active. For example, in the Ariel University case against Spain, it wasn't any Arab organization that pursued this with the Spanish Ministry of Housing. It was Israeli Jews in the United Kingdom that were principally responsible for the expulsion of a Jewish Arab architectural team from the 2010 Solar Decathlon competition. They made it to the finals, and they were about to participate in the finals among 20 finals in the world. And because of these activities of these people, they were thrown out, and we were left to seek redress in the Spanish courts. That's unfortunately the situation. I don't know if I can go more than that, or it's appropriate for me to go any further than that. Those comments. Are you there, Natasha? I don't hear you. Oops.
I'm so sorry, I'd muted myself.
Okay, I thought it was...
There's a first. But I was just saying that, talking to myself, so much of that, of course, is dependent on education and the sort of misinformation that these organizations are propagating, which undoubtedly continue these sorts of initiatives. It ties in with one of the questions or statements perhaps that's come from the audience, which says, is it not also true that BDS is dangerous because it parallels Israel and the false allegations of apartheid to South Africa, where boycott was effective in combating racism and in bringing down a government? So I think one can even see a cycle in that respect with respect to.
There's no question about that. And the point of education is really one that was the last, I think, on my list of conclusions. But it probably is the most important. I fully agree with you. And that's not something that private attorneys like myself can really do. It's up to organizations like yours and Eliza Lewin's Brandeis Center and the Zionist Organization of America and other organizations, all who really are concerned about the condition of the Jewish people and supporting the state of Israel. It takes that kind of grassroots education to begin to combat this very toxic, these toxic arguments that are being invoked without any justification, in my view, by the BDS activists, including the canard about Israel as an apartheid state. I mean, anybody, we all know many folks who come to Israel and other parts of the world from South Africa who understood what the apartheid regime was about. There is nothing comparable to that in Israel today. We need to go into that discussion, but the fact that someone actually raises it and people in high positions of authority, like the UN reporter for the Council of Human Rights Council, what's her name, Albanese?
Yes,
You know, she makes this comment, and you see it repeated by grassroots organizations, anti-Semitic organizations, and progressive organizations in the United States and around the world. Public education is ultimately the most effective weapon that we can have against the toxicity of the BDS movement.
I'm going to try and squeeze 3 more questions in the few minutes we have remaining. Marc, very briefly, one questioner asks whether you try and negotiate with BDS parties prior to filing an action against them. Of course, the examples that you've given are primarily against the targets of that BDS rather than the BDS movement itself. But do you have any comments that you might like to make on?
I personally would never engage them in any kind of dialogue. We understand exactly what their goal is.
There's nothing to negotiate there, is there?
No, they are relentless in pursuing their goal. They will not let up. They will not let up despite the victories that we've talked about today. They are continuing. Discussing issues with them is a waste of time, and I think a strategic error of the first order.
Second, if I may, do you have any thoughts on what the Israeli government should do to address BDS?
Well, one thing they could do is find a spine and take an aggressive position in enforcing their own laws. I'm glad that they finally got around to enacting legislation to combat this phenomenon, the BDS phenomenon in Israel itself. But I have to say, we've seen, again, I don't want to get into too many details, but I think this is an issue in terms of the Israeli government that requires real leadership. You know, and again, I don't want to engage in partisan discussions here on the Israeli side. There's a lot. We have enough problems as it is. But let me just put it to you this way: when you see public protests about Israeli democracy, where people come in and are waving Israeli flags, okay, fine, and Palestinian flags, this is a problem. Okay, I understand the right of free speech and everything else, but the government in Israel needs to take hold of this issue. They grab a hold of the reins and make, at least on the educational side, make a clear and unequivocal statement about what the interests of the state of Israel and the Jewish people are on the issue of BDS, which seeks to destroy the state of Israel.
And of course, the first thing one requires from the government to be able to push back on it is a robust rebuttal of the libels that accompany the actions.
Yes, that's exactly right.
And again, it takes us back to the education point. My final question for you, Marc, and we have very limited time with our audience remaining, but it is, what really do you think are the next targets for the BDS movement? Do you have any instinct, anything that your experiences indicates to you,
Well,
maybe coming around the corner?
yeah, okay, so it's going to happen on a number of different fronts. I mean, as I said, they're relentless and they're very organized and they are very, very sophisticated and they're very well funded. Okay, so we're going to see it and across the board in a number of different areas. One of them is going to be continued pressure on large international companies to stop doing business with the Jewish state. I mean, that's why BDS got started, and that's what they'll continue. They succeeded with General Mills. General Mills denies that, but there'll be others that are going to be in their line of sight, and they're going to line of their target. That's going to happen. The other area that's going to happen in the United States, we talked about this legislation, the legal challenges to anti-BDS legislation. That's going to go on relentlessly. It's going to happen in the Fifth Circuit. I imagine you'll see other cases challenging other state laws and other state action around the United States. Eventually, that's going to come to the Supreme Court, and the Supreme Court will have to decide whether or not anti-BDS legislation meets constitutional muster. And I'm by no means 100% confident that they will. Okay, so for a lot of different reasons, not necessarily that they're supporting the BDS movement, God forbid, but because of constitutional principles that are outside of the BDS debate. So that's another issue. Also, you're going to see it increasingly. I don't know. Again, I imagine in places throughout Europe, you will see it in your own country. You've had political parties who are pushing candidates who are BDS proponents. Okay, and we see them in the United States. Unfortunately, you had one of your major parties in the UK embrace this idea. I think under its previous leadership. I don't know, and across the European continent and different places around the world, you're going to see an attempt by the BDS movement to change the composition of parliaments and legislatures around the world and elected officials. And finally, I think you're going to have the continued onslaught against the media, and the media is large. I mean, I just heard yesterday, I think it was a BBC reporter interviewing the Israeli Prime Minister Netanyahu, and it was really offensive in what he was saying to them.
Sky News. I mean, the BBC is
Sky News. Well, it's even worse. So, and unfortunately, the Prime Minister had a very effective, robust response. Thank God. But not everybody is capable of making those things, and it's very easy in today's cancel culture world, to be cowed into silence or into complicity.
Well, plainly, we cannot rest on any laurels, but the successes that you have had, Marc, are inspirational. They really have laid a pathway, I believe, for future initiatives to push back on this sort of lawfare, as well as the BDS movement and its initiatives against Israel. And I trust that will be evolving. And we must.
You, Natasha, that I will continue. Okay, as an individual. Many others will follow the same path, and many have, and so that we can fight this movement at its roots.
As indeed will we, and I'm encouraged to say that there have been messages from the audience from individuals wishing to contribute, wishing to help, wishing to partake, to which I would say, please do email us at info@uklfi.com. There are never enough individuals willing to assist with these sorts of projects, and as you say, they are so desperately needed. I'm enormously grateful for your work, you and your colleagues in the US and in Israel, of course, to Jonathan and Caroline Turner and all of those who've assisted on projects with UK Lawyers for Israel. There is still a great deal to be done, but I believe that we can take comfort from past successes and knowing indeed what is achievable.
It's an honor to work with your organization, and Jonathan, Caroline, and yourself, Natasha, and all your supporters. Really, kudos. Thank you.
Thank you so much for being with us. Have a good evening.
You too. Cheers.